Hello, welcome to the National Whistleblowers Appreciation Day. My name is Clayton E. I'm a partner at the law firm Ogborn Mim in Denver, Colorado. I'm an advocate for whistleblowers, both in retaliation claims as well as incentive and qui tam claims. Today, I welcome you to celebrating with me National Whistleblower Appreciation Day. Now, what is today? Now, recently, and pretty much every July for a number of years, the Senate has passed a resolution marking this as National Whistleblower Appreciation Day. It chooses July 30th of each year as the date for this National Whistleblower Appreciation Day because it's the anniversary. This year, 2019, is the 241st anniversary of America's first whistleblower protection statute. Now, that whistleblower protection statute, as we'll discuss, is very important for the precedent that it set, as well as for the language that it used and its recognition of whistleblowers as important members of our society. Now, the National Whistleblower Appreciation Day resolution that was recently passed by the U.S. Senate, it encouraged and called for the heads of the executive branches to inform their employees, their contractors, and other involved U.S. citizens of their legal rights as whistleblowers, their legal rights protecting them when they blow the whistle on illegal or unethical conduct. And this is important that government officials be charged with advising individuals that they are encouraged to come forward with information regarding illegal conduct, and if they do so, that they're protected from retaliation. Now, I want to talk a bit about the history of whistleblower statutes in the United States. And in particular, I want to start with the statute that Whistleblower Appreciation Day commemorates, the anniversary of its passage. In 1778, just after the Revolutionary War, two naval officers who had reported the mistreatment of prisoners of war on United States, at that time colonial ships, were sued by their commanding officer. Their commanding officer alleged libel against them for reporting his mistreatment of these POWs. And these two whistleblowers, they went to Congress, and Congress recognized the importance of what they were doing. And so it passed a resolution to not only protect these whistleblowers, but also provide attorneys and attorney fees for these whistleblowers so they could defend themselves in this libel lawsuit brought by the naval officer that they blew the whistle on. In doing so, Congress made some very important and very strong statements about the importance of whistleblowers in our society. Congress stated, quote, "It is the duty of all persons in the service of the United States, as well as all other of the inhabitants thereof, to give the earliest information to Congress or other proper authority of any misconduct, frauds, or misdemeanors committed by any officers or persons in the service of these states, which may come to their knowledge." Now, this statement was really Congress was saying that it is the duty of all persons, meaning that we all of us, citizens, non-citizens, residents of the United States, have a duty to report when we see illegal, unethical, fraudulent, improper conduct, particularly conduct that affects the very societal makeup, the very societal structure, the political structure of our country and our society. In this instance, in 1778, was extremely important. Reporting mistreatment of POWs, British soldiers who were at the mercy of colonial naval officers. There can be no more compassionate thing to do than report mistreatment of a foe. And so I think it's important that Congress, even in that time of great strife, in a revolution, was able to recognize the importance of a whistleblower in that context. Now, since 1778, there have been numerous other whistleblower statutes. One in particular is worth diving into in a little bit of depth into the history. The False Claims Act was passed in the 1800s during the Civil War. It's commonly known as Lincoln's Law because Lincoln was the president at the time of its passage. It was passed in response to fraudsters taking advantage of the Union Army. Individuals, vendors of goods and services would do things like contract to sell a certain number of horses to the Union Army. And instead of horses, they would deliver sick donkeys. Or they would contract to provide a certain number of barrels of gunpowder. And instead of gunpowder, they would provide barrels that were 3/4 full with sawdust. And so the Union Army was being substantially hurt financially by this conduct, by these fraudsters. And so what the Congress and what Lincoln did is they passed a law that adopted some ideas from historical British statutes, and in fact British custom going back to kings and queens of old, that allowed an individual to step into the shoes of the government and report the fraudulent conduct of an individual that ended up costing the government, or in British times the monarchy, money, and report that conduct to the government. And if they were able to bring a claim successfully against the fraudster, the individual, commonly known as a relator, would be entitled to a certain percentage of whatever they were able to recover. And these lawsuits, commonly referred to as qui tam lawsuits, are an important mechanism to enforce statutes prohibiting fraud against the government and protecting taxpayer dollars. Now, since the passage of the False Claims Act in the 1800s, there have been several other statutes that have come along. One in particular, in 2002, in the wake of the WorldCom and Enron scandals, was the Sarbanes-Oxley Act. The Sarbanes-Oxley Act provided broader corporate compliance requirements for publicly traded companies. But Section 806 of that statute provided strong anti-retaliation protections for whistleblowers who either internally or externally to the government, Congress, or others reported things like wire fraud, mail fraud, shareholder fraud, violations of Securities and Exchange Act rules or regulations, or other fraud against shareholders. And it was important to bring this statute and to provide this protection because, as we saw in cases such as Enron, there were internal whistleblowers who came forward and were essentially ignored and pushed out. In the investigation that followed the Enron debacle, there was discovery of memos discussing what to do with an internal whistleblower. And ultimately, the in-house attorneys for Enron came to the conclusion that, yeah, she may have been reporting what she believed was illegal conduct, but she had no protection. The state she was in, Texas, provided no protection. Federal law provided no protection. So Enron could do anything with her that they pleased, so they terminated her. And Congress saw that it was important to protect these sorts of individuals from retaliation so that they could continue to report in-house and they could try to rectify these problems before they affected society as a whole. The next statute that I believe is an important occurrence, much more recent, is the passage of the Dodd-Frank Act in the wake of the Great Recession. That statute, in addition to creating broad regulations of the banking industry, the mortgage industry, etc., provided for two things. It provided for a bounty provision and procedure for individuals who reported violations of securities statutes as well as commodities trading statutes to the SEC or the Commodities Future Trading Commission. In those circumstances, it provided that individuals who provided information to those agencies, and the agencies were ultimately able to make a recovery based on that information, those whistleblowers were entitled to, and still are entitled to, a certain percentage of whatever the government's able to recover. So providing those incentives for whistleblowers to come forward and report to the government. The Dodd-Frank Act, as we'll talk about a little bit later, also provided strong anti-retaliation protections for individuals who reported securities fraud, bank fraud, and other violations of Security and Exchange Act or or the Commodities Future Trading Commission rules and regulations. The Dodd-Frank Act also created the Consumer Financial Protection Bureau under the Consumer Financial Protection Act, which contains its own anti-retaliation provisions that provide corporate whistleblowers with additional coverage for reporting violations of the Consumer Financial Protection Act and the rules and regulations that fall within the Bureau's jurisdiction. There are really two paths for a whistleblower to take. And I, as an advocate for whistleblowers, represent whistleblowers in both paths. There's those whistleblowers who report what they see as wrongful conduct, oftentimes by their employers, and they report it internally or externally sometimes, and they suffer retaliation for doing so. They can be terminated, they can be demoted, their pay can be cut, they can be put on a performance improvement plan. Things such as, and I've seen things such as a whistleblower being relegated to the proverbial Siberia of the office. Their office is moved to a broom closet. They're forced to work extreme hours. They're placed on essentially unattainable goals and set up to fail. These are the sorts of retaliation that whistleblowers often face. There's also a bounty, incentive, or qui tam path that whistleblowers take. And those are under statutes like the False Claims Act, the Dodd-Frank Act, the IRS Whistleblower Program, and FIREA, some of which we'll talk about here in a bit. These statutes provide whistleblowers with a monetary incentive for reporting illegal conduct to state and federal governments. In return for reporting such conduct, whistleblowers are given or awarded a certain percentage of whatever they or the government is able to recover based on the information the whistleblower provides. And so these incentive programs, coupled with the anti-retaliation protections, really provide both a front-end and a back-end incentive and protection for whistleblowers to come forward with information. And as we saw, since 1778, Congress has recognized how important whistleblowers are to our country. Now, there's a few major areas of whistleblower litigation. The first major statute, and oftentimes the statute that people think about when they think about whistleblowers, is the False Claims Act. The False Claims Act provides a qui tam provision, a provision by which a private individual can step into the shoes of the government and sue a fraudster on the government's behalf. And in return, that private individual is entitled to between 15 and 30% of whatever they or the government are able to collect based upon the information that they provided. Now, there's a myriad of different requirements under the False Claims Act, such as filing the complaint under seal, serving the government with disclosure statements in a timely manner, and doing a multitude of other things, and keeping the case confidential in order to become a successful relator. But these cases have broad impact. The False Claims Act often affects large government programs, things like Medicare, Medicaid, grants, procurement. All of these huge multi-billion-dollar industries are affected and controlled by the False Claims Act. And so you'll see cases of Medicare and Medicaid fraud, for instance, where with penalties and trebling of damages, the government's able to recover hundreds of millions of dollars from these fraudsters. And relators are entitled to a significant chunk of that money when the information they provide leads to that recovery. So it's a powerful mechanism for whistleblowers. The False Claims Act also has its own anti-retaliation provision, which was recently strengthened to cover both preparing for and bringing a qui tam lawsuit, as well as taking actions to stop one or more violations of the False Claims Act. So whistleblowers under the False Claims Act, again, are provided that front-end retaliation protection and that back-end incentive. And those are important protections and incentives for whistleblowers. There's also the Dodd-Frank and SEC whistleblower program, under which a whistleblower can report information to the SEC as well as the Commodity Futures Trading Commission. And if the SEC or the CFTC brings an action and is able to make a recovery based upon the information that the whistleblower provides, the whistleblower could be entitled to a percentage of what the government's able to recover. Both of these statutes also provide for strong anti-retaliation protections. Unfortunately, those protections in the case of the SEC provision were limited recently in the Digital Realty v. Summers case decided by the Supreme Court, which we'll talk about in a bit. Another strong whistleblower incentive program is the IRS Whistleblower Incentive Program. Under that program, an individual can report tax fraud, multi-million-dollar tax fraud to the IRS, can report circumstances or schemes in which individuals or companies are illegally avoiding tax liability. It has to meet a certain monetary threshold. But in return, the IRS will pay those whistleblowers a certain percentage of the penalties and back taxes that they're able to recover. So again, it provides a great incentive for whistleblowers. Unfortunately, the IRS program has essentially been a black box, where whistleblowers simply provide the information and the IRS take no more action. So the Dodd-Frank Act and the IRS provision are similar in this way, and different from the False Claims Act provision. Because where in the False Claims Act provision, a relator can litigate on behalf of the government, under both the IRS and SEC provisions, the whistleblower is relying solely on the government to bring those cases and achieve a good outcome. So a little bit different mechanisms, but still providing incentives for whistleblowers to come forward. There's also another program with the acronyms of FIREA and FIEFA. These statutes were passed in the 1980s after the savings and loan debacle. And essentially, they're a mechanism by which a whistleblower can attain an award based on reporting of bank fraud against an FDIC-insured institution. This statute, in combination with the False Claims Act, has been used to bring a lot of fraudulent mortgage lenders to justice. Individuals and companies who provided mortgages, falsely backed mortgages, to FHA and VA lenders, borrowers, things like that. Now, there's also a whole subset of anti-retaliation protections that are not necessarily attached to bounty programs. There are statutes that are administered by OSHA, which we normally think about in the context of worker safety. But OSHA is also empowered to investigate and do the initial intake for over 29 different statutes that provide anti-retaliation protections for whistleblowers. Things like reporting trucking safety violations under the STAA, reporting airline safety issues under the Air 21 statute, reporting violations of environmental statutes such as CERCLA and the Clean Air and Clean Water Act, reporting securities and corporate violations under the Sarbanes-Oxley Act and the Consumer Financial Protection Act. These are all examples of the statutes that OSHA administers. And the vast majority of these statutes, and in particular the Sarbanes-Oxley Act and the Consumer Financial Protection Act, provide for very strong protections for whistleblowers. They have a causation standard that is very favorable for whistleblowers. Essentially, what they require is that a whistleblower prove that their protected activity, their reporting, was a contributing factor in the adverse action that was taken against them. What this means is that they have to prove that their protected activity was a factor, just one factor. It can be one amongst 99 other factors that contributed to the decision to take an adverse action. But so long as it was one factor, that causation standard, that link between the protected activity and the adverse action is sufficient. There are also protections for national defense contractors under the NDAA for individuals who report waste, fraud, and abuse in those sorts of contracts. Those claims are oftentimes brought with anti-retaliation and potentially key TAM claims under the False Claims Act. There are also protections for government whistleblowers, both state and federal, under both the Whistleblower Protection Act, various state statutes, as well as the First Amendment and through Section 1983 claims. Now, I want to talk a bit about major cases and events that occurred over the last year in the whistleblower arena. Now, it seems like every major story, every major book, every major scandal that comes up has some whistleblower involved. I'm thinking here of Dinesh Thakur, the Ranbaxy whistleblower who was featured in Catherine Eban's book, Bottle of Lies. And he exposed the rampant manufacturing problems with generic drugs in India. Essentially, generic drug manufacturers who were creating drugs that made medical problems worse, not better, for both US as well as global patients. I'm thinking of Tyler Schultz, the whistleblower who exposed Theranos and the fraudulent drug tests that it was marketing, as documented in the book Bad Blood. You know, it seems like every one of these large scandals has a whistleblower involved. And that shouldn't be a surprise to us, because when these sorts of societal problems arise, we often only hear about it because of individuals who have the ethical and moral backbone and compass to bring those problems forward and to report them, both to society as a whole as well as to the government. Now, from a regulatory perspective, there have been several events that have occurred. One of the important events was the strengthening of the IRS whistleblower program. Under the Taxpayer First Act that was recently passed and signed into law by the President, the IRS whistleblower program was strengthened in several different ways, but most notably, an anti-retaliation provision was added. Previously, an individual who reported tax fraud to the IRS was not protected from retaliation. Now, with the Taxpayer First Act, that is no longer the case. Further, there were also requirements put in place for the IRS to actually talk with a whistleblower about the process and about the information they've received, which has made the IRS program a little less of a black box for whistleblowers to report. There's also a bill currently pending before the U.S. Senate called the Whistleblower Protection Reform Act of 2019. This bill, which is already passed by the House, would reverse and overturn the U.S. Supreme Court's decision in Digital Realty v. Summers. And that's the case that limited the scope of the Dodd-Frank's anti-retaliation provision to only protect whistleblowers who reported information to the SEC first. In other words, a whistleblower who internally reported violations of SEC rules and regulations was not protected from retaliation under the Dodd-Frank Act, unless they had previously reported to the SEC. Now, what this caused was an incentive for whistleblowers to report all sorts of bad conduct to the SEC in order to potentially receive retaliation protection in the future. And so, both from a corporate governance perspective, as well as from the perspective of protecting individual whistleblowers, what hopefully Congress will see is that there is much to be gained by protecting individuals who report only internally. First, it gives whistleblowers much more protection in a much broader range of circumstances. And secondarily, it allows corporations to practice good corporate governance, to address the issues raised by whistleblowers prior to them being reported to the government, which frankly should be a top priority for all publicly traded institutions. So we'll keep our eye on that to see if Congress hopefully passes that and the President hopefully signs it. Now, another big recent event is the use of the False Claims Act to battle the opioid epidemic. You know, as we all know, opioids and eventually heroin have been a scourge in our country and have resulted in many unnecessary deaths. Individuals becoming addicted to opioid painkillers and either overdosing on those or eventually moving on to heroin and potentially overdosing on that drug have become an extreme problem in our country. Recently, the DOJ, with the help of whistleblowers, have used the False Claims Act to battle this and to hold pharmaceutical companies responsible for that opioid epidemic. In particular, the DOJ recently announced a $225 million settlement with Insys Therapeutics, a manufacturer of a fentanyl or synthetic opioid drug. That settlement was based upon a speaker program that provided extreme incentives for doctors to prescribe instance fentanyl products in violation of the anti-kickback statute, which is per se a violation of the False Claims Act as well. The DOJ press release described a particular situation that is emblematic of what was going on. Quote, after joining the sham speaker program, the physician's assistant wrote approximately 672 Subsys, the fentanyl drug, prescriptions for his patients, many of which were medically unnecessary, and in turn received $44,000 in kickbacks from INSIS. Now, these sorts of kickbacks and fraudulent schemes in order to market drugs that eventually ended up, frankly, killing people are a large societal problem. And it's great to see whistleblower statutes such as the False Claims Act being used to combat those problems and hold these large pharmaceutical companies responsible. Another aspect of recent whistleblower issues are government whistleblowers. We are currently in a time when the executive branch of our government likes to refer to whistleblowers and leakers as, quote, traitors. This seems antithetical to the statutes that Congress passed as far back as 1778. In those statutes, in those resolutions, there was a recognition that whistleblowers matter, that it is the duty of all citizens, particularly government employees, to blow the whistle on and report what they see as illegal, improper, unethical conduct, and particularly conduct that violates our government norms and our government statutes. And so this demonization of whistleblowers is problematic, both from a government perspective as well as from a corporate compliance perspective. The DOJ recently came out with guidance regarding corporate compliance. And one of the factors they look for in assessing a corporate compliance program is how they treat whistleblowers, their anti-retaliation protections. And does the company recognize that whistleblowers are beneficial to the company? Do they provide strong protections for the whistleblowers? Do they provide strong training that both encourages whistleblowers to come forward, but also trains managers and supervisors on how not to retaliate, how to encourage their subordinates to come forward and report, and how not to take small steps that in their minds might seem like dealing with a problem, but are in all reality discouraging individuals to come forward with important information. So in that corporate and that government context, I think it's very important that we use the proper verbiage, that we provide the proper reverence for whistleblowers. That these are people with moral fortitude. These are sharp pencils in the room who are not going to let illegal conduct slide. They're not going to sit there and watch as a company makes money hand over fist because they're engaging in fraudulent conduct. They're going to stand up and they're going to raise their voice. And those people should be encouraged, not punished. And that's the entire point of National Whistleblower Appreciation Day. Is to appreciate and reinforce whistleblowers. The New Yorker came out with an article recently focusing on the personal sacrifice and the professional sacrifice that whistleblowers go through. Individuals who report Medicare fraud, who report fraud against the government, individuals who report, such as in the Rambaxi case, who report generic drug manufacturing problems in India. All of these individuals take great personal and professional risk in order to provide a societal benefit, and that needs to be recognized. So with that, I wish you a happy Whistleblower Appreciation Day. My name's Clayton Wire. I'm with the law firm Ogborn Mim. Thank you for joining me.